Good afternoon. My name is Ashanti Payne, and I am the Assistant Director in the Office of Equity and Equal Opportunity here, at the Metropolitan Council. And we are more than pleased to provide this information session in our effort to ensure that the folks that are doing business or intend to do business with the council understand some of the changes that are occurring at the federal level, the landscape, both legally and politically, that impact the programs and work around this effort. And you have a chance to interact with us, ask questions, tell us what your thoughts, concerns might be, where some of your pain points, risks that you see, and be as responsive as we can to ensure that folks can participate in our programs, activities, and services successfully. And in that vein, we've invited or contracted with Colette Holt. And I've known Colette for many years. I've been doing this a while, and it is rare that I run into people that have been doing this as long or longer than I have, and I can humbly say knows more than I do around this work. So Colette also serves as the General Counsel to the American Contract Compliance Association. That is the only association that gives accredited certification in this realm and in this work. She's been a contract attorney or contractor attorney, been doing this work for a long time, definitely is knowledgeable. And we are more than pleased to have her be our expert in presenting this topic. So without further ado, I'm going to turn it over to Colette and let her begin.
So this is the agenda. I'm going to cover some recent cases, litigation outcomes, and possible responses. And then the new DBE rules revisions, which were effective May 9th. And then at the end, we can have questions and discussions. My preference is that people put their questions in the chat, simply because it's just easier to manage. And if Megan or whoever is managing the PowerPoint can read them to me, that would be very helpful. And I'll stop after the cases to see if people have any questions, because it's a lot of material and it's a long session. So we can certainly do that. Oh, all right. Now I have my camera back. Okay, so I can see myself and you can see me. Makes it a little bit better as it's live. So next slide, please. Let me see if I can get everybody to be quiet behind me. Oh, there we go. Okay, good. I'm going to start with a case that actually is from a couple of years ago now, but it's important because it really has set the stage for many of the other cases that have followed. Some of you may know that there's been quite a lot of litigation in the last couple of years about race-conscious contracting programs. And I wanted to talk about the cases because I think they are, first of all, top of people's mind. And secondly, they really are going to have an impact on the DBE program. I just don't think there's any way around that. And although we now have new regulations that enhance the program, modernize the program, I think there's real questions about what the shape of the program is going to look like. And that's especially true after the election. I did see that there is a proposed new head of USDOT, and the person proposed to be secretary doesn't seem to have any real transportation background. So I guess we'll see about that. But I did want to talk about the cases as well. So we had plenty of time for this session, and so we can ask questions and see how it all fits together. So the first case I want to talk about is called Vitolo versus Guzman. And this was a case that arose from efforts by Congress during the pandemic to get relief to socially and economically disadvantaged restaurant and owners, women and veterans. You may remember that in the early days of the pandemic, when Congress was just sort of shoveling money out the door, that most of the money in the restaurant industry was going to very large chains, Darden Foods, Starbucks, whatever. And so Congress wanted to be sure that small restaurants would have an opportunity to get relief. So the Small Business Administration, and that's where Guzman comes from at the time, that was the administrator for SBA, developed a program that prioritized applications for grants for small restaurants for 21 days for restaurants owned by socially and economically disadvantaged individuals, women, and veterans. And the phrase socially and economically disadvantaged should sound familiar to many of you, because that is the same test that's used in the US DOT DBE program and many other programs throughout the federal system. It comes straight out of the Small Business Act. And the applicants just got to go to the front of the line. They didn't get any more relief. So it really was just for the first 3 weeks that priority was given to these applications. And so the SBA was sued, and both at the district court level and at the Court of Appeals level, the program was struck down. And that's one of the reasons I include this case, even though it's restaurants and not construction, is because this is a Court of Appeals opinion from the Sixth Circuit, which does not include Minnesota, but I think it is a harbinger of things to come. And my guess, I don't know this, but my guess is that the addition of veterans was an attempt perhaps to insulate the program from challenge. And as you will see in a second, that did not work. So the court said that the program fails what's called strict constitutional scrutiny. Strict scrutiny is the highest level of judicial review, and it has been applied by the federal court since 1989 to programs that are race-based in terms of some type of benefit or focus. That comes out of a case, City of Richmond versus the J. Croson Company. That Croson case may be familiar to some of you, where an opinion by Justice Sandra Day O'Connor, the court really upended long settled constitutional law and held that programs designed to address the continuing effects of discrimination are to be reviewed with the same sort of jaundiced eye or level of scrutiny as programs designed to injure racial minorities. So affirmative action is to be viewed the same way as you would, let's say, view the poll tax or something like that. And in the wake of Croson, we developed disparity studies and all these different mechanisms to try to address what was then a new legal test, but that test is called strict scrutiny. And strict scrutiny has two components. The first is that the government must establish by a strong basis in evidence that it has a compelling interest in using the highly disfavored tool of race-based decision-making. So here you see that the Court of Appeals held that the racial component of the program, in other words, the definition of socially and economically disadvantaged, failed this strict constitutional scrutiny test. First, that there is no compelling interest, that the legislation fails to target specific instances of identified discrimination. Well, in the middle of the pandemic, kind of hard to know what that would have looked like or where Congress would have gotten such information. And really this, and you're going to see this in the other cases as well, this instances of identified discrimination is really in many ways a trick bag. Because if the agency has evidence of identified intentional discrimination, then why isn't the answer, well, go do something about it? I'm not sure why a contracting program or any other type of program would be the answer to that. But in any event, the court says that Congress didn't have this type of evidence, and that any discrimination must be intentional. And I quote, statistical disparities don't cut it. And I think this certainly has implications for disparity studies, which have been my main professional focus for 30 years now, because statistical disparities are how we have supported these programs for decades now, not instances of intentional discrimination. But in any event, the Court of Appeals then says that the government must have participated in the past instances of intentional identified discrimination. And again, I mean, this just seems like it'd be impossible in the middle of a pandemic, when, of course, as we all remember, things were just falling apart. Next slide, please. The second component of strict constitutional scrutiny is that the program must be narrowly tailored to the evidence upon which it rests. And here the court says that the program is not narrowly tailored, that there's no consideration of serious workable race-neutral alternatives, that the categories in the Small Business Act are overbroad and under-inclusive at the same time. And this is an objection that you're going to see in other cases, and then it has been extended beyond just this particular pandemic era program to the DBE program, to the 8A program, et cetera. So the court says, for example, that the program includes Pakistanis but not Afghans, Japanese but not Iraqis, Hispanics but not Middle Easterners. And this really is an objection to the list of minority groups that Congress determined should be covered by the Small Business Act. And this idea that, it's just kind of a kitchen sink and that there's no rhyme or reason to it has been, unfortunately, successful recently. The court then says that the program overly burdens non-presumptive groups, that it's just unfair to white men who didn't serve in the military, and then that the 51% ownership requirement to be considered a firm owned by a socially and economically disadvantaged individual, a woman, or a military veteran is arbitrary. Now, I don't understand this. I understand the rest of the opinion. I disagree with it, but I understand it. I do not understand this ownership issue. The bedrock of certification in all these programs since the beginning has been that the woman or minority or veteran owner or whoever it is has to own 51% of the firm in order for it to be considered minority, for example, owned. It's hard for me to believe that if the percentage had been 40% or 60%, that it would have made any difference at all to the outcome in this case. But I just don't really understand where this objection is coming from. When I went back and looked at the briefs, this was really not argued by anybody, at least not much. And so I don't fault SBA for not really putting much of a defense on, because nobody thought that this was an issue. So this is just the court just grabbing something out of the air and relying on it. So that's the race-based component, social and economic disadvantage. The court then goes on to look at the gender component. And there is, at least in theory, a somewhat looser or lower standard of review for programs that provide benefits on the basis of gender. And that lower standard is called intermediate scrutiny. So it's intermediate between strict scrutiny on the one hand and rational basis scrutiny on the other. And rational basis is just pretty much, did the decision maker or the legislature or the board or whatever have any reasonable reason for doing what they did? So this is this kind of in the middle idea. And it comes from cases challenging the male-only draft during the Vietnam War. And in an opinion by Thurgood Marshall, of all people, he says, well, you know, gender's a little bit different. We look at it through a less aggressive stance. And that's why it was okay to only draft boys and not girls. So in theory, there is this intermediate scrutiny. I have believed for some time that this is not real. And again, you know, just to be really clear, this is me speaking for myself, not for the council or for anybody else. But the last case that upheld a gender component while striking down the race-based component was in 1990. And so the courts say that they apply intermediate scrutiny and then promptly strike the program down anyway. So I personally don't think that this matters, that the same test is being applied to gender as to race. And certainly in this case, you get the same outcome. No instances of identified discrimination against women. There was not even an economic disadvantage test for women, which there was for racial and ethnic minorities. And again, that this 51% ownership requirement is arbitrary. Next slide, please. So that was the restaurant case, the Vitolo case. And I thought that that was a way sign on where the federal courts were going with these programs. There had been a series of slightly earlier cases challenging a pandemic program for socially and economically disadvantaged farmers and ranchers, sort of colloquially called the Black farmer cases. And we had lost all those. And the other thing about the Black farmer litigation was that these cases were filed all over the country almost simultaneously, which said to me that there was a really organized, intentional effort to get rid of that program. And it wasn't like it was any really big deal in the whole balance of the federal government, but I think that people saw a weakness, and that these groups that are opposed to affirmative action and civil rights saw the opportunity to use that program as a way to create a new body of law. And that is actually what I think you are seeing. And as we go through these cases, you might see why I make that argument, that this is really an organized attempt to create a new body of law, that it really is overturning, again, decades of settled law about what you have to do to prove up and support a race-based contracting program, and that the landscape is shifting very, very, very rapidly. So the next case that's in this line of cases is called Newsyard versus the Minority Business Development Agency. Now, MBDA was first created in the Nixon administration. And I suspect there are people who were at this call who, in fact, weren't born yet. I don't think any of us ever thought of MBDA as some type of controversial idea. They provide technical assistance and that kind of thing to minority-owned firms. They are not themselves really a contracting organization. But they were sued, and full disclosure, I was the Department of Justice's testifying expert in this case. So I can tell you a lot about it, and what is disturbing, aside from just losing in general, was the first case I've ever lost in this area. What it tells me about where things are going. So one of the things that the plaintiffs are doing in these cases is they're doing what is called forum shopping. And what we lawyers mean by that is that people are picking where they want to file the lawsuit. Venue, or where you can properly file a lawsuit. A venue, that's a legal term for that. Venue is proper against the United States in any federal district court in the country, anywhere. So the plaintiffs are picking courts that they think will be very sympathetic to them. And in fact, they filed this case in Texas, in the Fort Worth district, and they got the Judge Kosmeric, who you may recall was the one who outlawed or attempted to outlaw mifepristone, the abortion pill. He is a very, very, very conservative Trump-appointed Federalist Society guy. And the plaintiffs went there, I believe, specifically because they had a very good chance of getting him. And he, in fact, did strike down the program. He said that MBDA lacks a compelling interest. And in what is, to me, the worst quote in the entire opinion, he says, "Time's up." Essentially that we've spent enough time and it's been long enough to try to do something about the effects of racism. And it's kind of a, well, we're done with that now mindset. He says that there's no evidence for all the included minority groups or all the types of businesses served. The government cannot create a patchwork of racial preferences based on statistical generalizations. Well, again, that is a direct dagger in the heart of disparity studies and the way that we have supported these programs now for decades using statistical evidence of disparities. Broad statistical disparities are not sufficient in his view. The evidence must be industry specific. Now, he doesn't give us any guidance about how specific. Could it just be construction or professional services? Or does it have to be more granular than that? Who knows? The disparities must be linked to intentional discrimination by eliminating all variables that could account for the disparities. Well, I can tell you as somebody who's done this research now since 1990 that this is impossible. You cannot link statistical evidence to intentional behavior by anybody. The whole point of statistical analysis is to look at patterns, not at individual sets of facts, let alone the intentionality of any individuals involved in these individual facts. This is just cannot be done. The other thing is that you can't ever eliminate all variables. What you can eliminate are variables about which you can get sufficient data to actually run the regressions. There's all kinds of variables. You know, why, this firm didn't get a bid because they had to deliver the bids in person and the guy had a car accident on the way to the owner's office. I mean, you just cannot do this. And I assume that this judge is bright enough to understand that. And so this to me is a very disingenuous test, because don't give me a test and tell me I can't meet it, then just simply say that we're not going to permit it at all. He goes on to say that the government must have participated in the past discrimination it now seeks to remedy. And again, what would that look like? One of the things that we always took from the Croson case and the body of law that's been developed since Croson was that the government, in fact, did not have to prove that it itself participated in the discrimination that it's trying to ameliorate. No sane government lawyer is going to go into federal court and say, "Good afternoon, Your Honor, my client discriminates." And again, if that's true, then fix it. Why do you need a program? So this is just simply not workable. Next slide, please. The program is also not narrowly tailored. That's the other component of strict constitutional scrutiny. So in addition to having to establish the compelling interest in using race through a strong basis in evidence, you also have to prove that the program that you adopt is narrowly tailored to the evidence upon which the agency relies. The court says race-neutral alternatives have not been tried, and that the government has failed to show that no alternative would achieve the interest. He dismisses this report that we did from 2016 about disparity studies because, and he is correct about this, it does not detail which agencies have implemented race-neutral measures and the success or failure thereof. So I think this has implications for agencies going forward about what kind of data you might want to collect. Next slide, please. So back again to this idea that the program is under-inclusive and scattershot. Again, MENA individuals are not included. And back to this this puzzling 51% ownership point. He says the program could be over-inclusive because it may help individuals who may never have suffered any kind of discrimination. Well, the decision was made not to appeal this case. And MBDA has now revised its intake and the website to make it clear that it is now open to all firms to provide the type of supportive services that it was heretofore only providing to minority-owned firms. Next slide, please. So that's the MBDA case. Now, the third case involves the Small Business Administration. This one got more national play. I think maybe because people knew more about the 8A program. And there may be some people who are here today who have been or are 8A contractors. But the 8A program's presumption of social and economic disadvantage for the listed minorities in the Small Business Act was struck down under this strict constitutional scrutiny framework. The plaintiff was a white female who lost contracts when the work that she did was moved into the 8A program, and then only 8A firms were going to be eligible. And note that 8A does not include white women in the groups that are presumed to be socially and economically so she was not eligible for 8A. Now, there is in theory a process to come in on your own, but she didn't even try that, I guess. Court goes on to say that, again, the program is not based on a compelling interest. So you see the same framework being applied across different types of programs. And no, this is not just a sloppy cut and paste job by Colette. They are all citing each other now. So you are seeing the targeted, intentional development of a body of case law that is self-referential at this point, because they're all saying the same thing. Broad statistical disparities aren't sufficient, that you have to have evidence for all the minority groups or all the businesses that you want to serve. Next slide, please. Again, this idea about linked discrimination and intentional intention and eliminating all the variables that could account for the discrimination, that the government must have participated. It's the exact same set of factors or standards being used across all these cases. Program's not narrowly tailored. There is no termination date, that is true. And there are no specific remedial goals, not like in the DBE program where we have a national goal of 10% of dollars to be spent with DBEs that are federally assisted transportation dollars. Again, it seems disingenuous to think that, oh, if they had had a specific objective, that would have saved the program, but he does go on to say that. So SBA decided not to appeal this one either. And instead worked out something with the plaintiffs where now individuals are required to submit personal narratives of their social disadvantage. If you want to see what that looks like, there's guidance at sba.gov. It will show you a checklist and things to think about. There is help available to put together your narratives. The plaintiffs, however, are kind of taking a wait and see mode. They have made the argument that SBA is telling people what they have to say, paying people to help them say it, and then will be the arbiter of whether or not they said it, and that is not sufficiently independent. We'll see what happens with that. Next slide, please. So now we come to the Mid-America Milling case. And this is the case that recently struck down the use of DBE contract goals in the DOT program. So this is now the one closest to the heart of the work that I do and the DBE program that the Met Council and other agencies like Minnesota DOT administer. This is really a very odd case in a lot of ways. The plaintiffs are two subcontractors. One is a milling company, the other is a trucking company. And the court struck down the program in Indiana and Kentucky because that's where the plaintiffs were, and now in other states. So there's been kind of an iteration of the outcomes of the actual orders over the last couple months. But we are now in the interesting position that we have two firms that are determining which contracts have goals on them. But anyway, to turn to what the court says, and we'll go back to the impact of it in a minute. Court cites Students for Fair Admission. That's the Harvard case, the Spatolo case, Ultimate case, and the Newsyard case. Ignores decades of case law upholding the U.S. DOT DBE program. Now, when I was a law teacher, if a student failed to acknowledge countervailing case law, that's pretty close to a fail. You're always free to argue for a good faith change in the law, extension of the law, but you have to acknowledge what the law is. And these cases, they just aren't doing that. They just ignore everything, as if there hadn't been the cases against Caltrans and the Illinois DOT and the Minnesota DOT. That was one of the very first cases that was ever filed back in the 90s, Sherbrooke versus the Minnesota Department of Transportation, which I worked on. And so I got to meet Ashante, and MnDOT was one of my earliest clients when I opened my own firm. But just the decision just ignores it, just completely ignores these cases. Says that the racial presumption again fails strict scrutiny, same stuff. Was particularly discouraging was the rejection of the very extensive congressional record of the continuation of discrimination in the market for federally assisted transportation contracts. I had testified, with Congress, and we worked really very hard, a big group of us, on putting together that record, and the court just dismisses it. One thing I forgot to mention in the Minority Business Development Agency case, that I had an expert report that was huge. It pulled together all these different disparity studies, and we knew we were in a different world when the plaintiffs first didn't try to challenge me as an expert. We were quite sure we could win that, but it's pretty standard to do that. The second thing that they did not do was they did not name their own expert, and then they never even bothered to depose me. So they didn't challenge the evidence. And I think this is something people just have to get their heads around. They didn't challenge the evidence. They said, we don't care what the evidence is. The program's gone on too long. And the court agreed with that. Same thing seems to be happening in this Mid-America case. It wasn't like the plaintiffs came in and had their own experts and attacked the studies or anything that we were used to in the way that we used to litigate these cases. They just basically ignored it, said, we don't care, can't keep doing this. In the court, the minority groupings are too broad, same concept. US DOT must have specifically discriminated against each group listed. Impossible. First of all, it's not true. And secondly, what kind of evidence would you need to demonstrate that US DOT itself had discriminated against all these people? It's not going to happen. Next slide, please. Goes on to say that the program is insufficiently narrowly tailored. Back to this concept, same scattershot, same individual approach is too burdensome. But there's no logical end point to the program. And the fact that Congress engages in regular review is simply not enough. The gender presumption fails intermediate scrutiny, as it has everywhere else. One thing that particularly stands out is that the court says that there's no evidence of blatant or intentional discrimination by US DOT against women contractors. So the original order said that the injunction applies to contracts on which the plaintiffs bid. Well, that was a head scratcher. First of all, they're subs, so they don't actually bid to any department. They submit quotes to prime. So that was its own issue, and really it's just an example of what has been always a challenge in trying these cases, is the fact that federal judges don't understand anything about how public contracting works. So of course, the second problem is you won't know what projects they bid on until they bid on them. So how will you know upfront whether a contract has goals? And it is not a tenable situation to have the goal only apply if the prime doesn't take a quote from one of these two firms, because now you've got differential standards for different bidders, and that there's no procurement law any place I can imagine where that would be tolerable. So that didn't make any sense. So the plaintiffs went back to federal court and got a clarification, and now the injunction applies to contracts anywhere in the country that the plaintiffs are interested in bidding on. And there is, in fact, a list of states that they have given to US DOJ and DOT that includes the state of Minnesota. And we recently got guidance about what to do. There is a process now for the plaintiffs to let DOJ know which contracts it's interested in. And then those contracts will be solicited without contract goals. So I do know, for example, that Illinois DOT just pulled a third of the contracts off the letting so that they can reissue them, reissue the solicitation without goals. I situation that we can't have whether or not goals apply to a contract dependent on the whim of two subcontractors. I just don't see how that's going to be sustainable. So my assumption is that other cases will be filed relatively soon. So we shall see. But I'm assuming that Minnesota DOT is going to have to pull any contracts off its lettings or solicitation schedules that these plaintiffs have expressed an interest in. They don't actually have to bid on it. And since they're subs, they don't control who would get the work anyway. So it's just this situation where I just think the judge doesn't understand how this works. So hopefully we will get some more guidance about that. I did a training this morning for North Carolina DOT actually, and somebody asked a really good question, which was, does this apply to consulting contracts? My argument is no, it does not. Because a milling company and a trucking company are never going to bid, whatever that might mean in this context, on an engineering contract. So presumably it does not apply outside of anything but roadway construction. And there's some question about whether or not it would apply to the other modal administrations in DOT. Obviously, this is federal highways, but what about Federal Aviation Administration, Federal Transit Administration, Federal Railroad Administration? Who knows? I mean, of course, I'm an advocate for the program, so I'm going to make you the argument that it's as narrow as possible. But on the other hand, they did sue Pete Buttigieg and the administrator of FHWA. They did not sue any recipient, which was a mighty bold move, I thought at the time, and it made me think, this is a problem. So, that's where we are with that. Certainly this push across the country with these organized groups that are extraordinarily well funded and have an ideological mission that they're trying to achieve. So, next slide, please. I included the two Houston cases because I don't want people to come away from any of this thinking, oh, well, that's just the federal program, my local or state program or my city program. This has nothing to do with it. Wrong, very wrong. There are two pending cases in the city of Houston. One is a challenge to the city's preference program, which was first enacted in 1984. So the comments about time's up ring in my head very much. They are also relying on a 2006 disparity study Query as to whether or not that's going to survive scrutiny. And you see the goals that they have. The MMD is something like the Midtown Management District, and that's a separate government from the city, although the city council does appoint all the board members. But they are in an even more, it seems to me, precarious position. They have no study at all. They give 10 points just for being a certified firm. So that's not good faith efforts or goals or anything. If you're a certified firm, you get 10 extra points. And if the plaintiff's allegations in the complaint are accurate, but for those 10 points, it would have been ranked first, but it lost out because the MBE just got those extra points. They are deep in discovery. The motion to dismiss by the defendants was denied, so keep your eyes on this one. If anything, I would suggest that some of these local programs are even more vulnerable than any of the federal programs would be. Because if Congress, and with all of its resources, is going to be not to have sufficient evidence, one wonders about some of these small municipalities or districts. Next slide, please. So, what's the pivot? I always like that phrase from Rahm Emanuel, who was President Obama's chief of staff and then the mayor of the city of Chicago, my home. Never let a good crisis go to waste. And so one thing for sure is that these cases now are getting people's attention. People told me for some years now, oh, they can't do that. The DBE program's here to stay, blah, blah, blah. And I'm like, I wouldn't be too sure. And I have been trying to sound the alarm about what's going on now for about the last 3 years. And now I think people are understanding that, yes, in fact, the federal courts can and they will reverse decades of settled law to enact a new political regime. I think it's really important to make sure that everybody understands that, where we are. If you're an agency, think about conducting what they call a SWOT analysis: strengths, weaknesses, opportunities, and then how to move forward. Think about increasing supportive services and technical assistance. These firms are going to have to be able to survive out here in an unremediated open market if these programs keep being struck down. And so what is it that DBEs and WBEs really need? Is it assistance with estimating or back office support? Is it marketing? Is it other types of compliance? What would help these firms? Certainly, money is a huge issue. And so financing and bonding support programs, I think, are something to be looked at and enacted and quickly. There are a couple of good ones across the country I'm aware of, and I don't do that at all, but I know people who are supposed to be good at it. They are expensive. But at this point, if people really are committed to trying to make sure that everyone has a full and fair opportunity to compete, we're going to have to start to beef that up. Same thing with small business program elements. If you can do it under state law, that really does vary. Down here in Texas, the Texas Local Government Code really makes it very, very difficult, if not impossible, to really have a real SBE program. Other places, very different. These are all things I think that recipients are going to have to think about. Next slide, please. So what can the large firms do now? And I know this session, we're going to do another one on Friday, has been more geared to the larger firms who are bidding, DBEs as well, too. But I think that certainly there are some things that you can do if, in fact, you are committed to having inclusive opportunities and ensuring that you are operating in a manner that is non-discriminatory. Reviewing your own in-house efforts, I think, would be very helpful. What kind of outreach are you really doing? Are you just sending out, emails to 3,000 firms and not really culling through that and following up? I get a lot of them firms that say, "Hi, we're bidding whatever, and please submit your quote on this bridge project." And I know that then they're not terribly serious about what they're doing because they're just sending out these blast emails with no intention really of trying to tailor them to the specifics of what it is that they need. If you have a pre-qualification process, take a look at that. Make sure it's no more burdensome than it needs to be, that the qualifications aren't higher than what's really necessary to then get into your program and be part of the bidding pool. If firms are applying and being rejected, take a look at why. Where are there weaknesses that are keeping people from becoming pre-qualified with you? And what, if anything, can be done to provide support and assistance so that firms can, in fact, meet those pre-qualification standards? If you have some type of mentor-protege relationship or teaming agreement with DBEs or MWDBEs, I'll just use DBEs for shorthand, it's quicker. Take a look at those too. Are they really serving their intended purpose? Is the protege benefiting? Are you, as the mentor, benefiting? Do you have defined goals, objectives, timetables? Or is it more of a kind of let's just go to lunch kind of a thing, which is not terribly helpful? Nothing wrong with lunch, but we really, if you really want to move things forward, you need objectives. Do you have sufficient staff resources? If you've just got one person who does DBE and internal EEO and external EEO and outreach and labor compliance, it's not enough. It's just not enough to be able to do anything that's going to be meaningful. And then finally, evaluate your business diversity documents. Let's just make sure you don't have something that's just glaring out there that could make you low-hanging litigation fruit. Think about measuring outcomes. What does success mean to your firm, your business in this area? Make sure you are, in fact, complying with Title VI. Title VI still exists. I don't know for how long, but it does. So if you are working on any type of government contract, you probably have Title VI requirements, and that can get very sticky. Some years ago, when the Washington State Department of Transportation was building the tunnel under Seattle, you may remember this if there are any engineers on the phone, where the boring machine got stuck in the tunnel. I think her name was Big Bertha. And so they had to shut the project down for well over a year while they just tried to deal with the fact that the boring machine was stuck. That project ended up with several Title VI complaints being filed to FHWA and the Department of Justice. WashDOT had to enter into a whole conciliation agreement and monitoring. And so failure to do it really can be a problem. And the contractors that were the joint venture team, design build team on that project, they got in trouble too. So Title VI is definitely something to pay attention to, and make sure that you've trained your staff adequately about all of this. Next slide, please. If you are a DBE, what can you do? Well, for sure, stay abreast of the legal developments. So if you're on this call, that's a very good start. Again, get prepared for what it will mean if there are no contract goals. Where does your operation need improvement? Be honest with yourselves, because contractors, if there are no goals, may feel like they don't want to be bothered with some sub who's got all these issues. Don't be the firm whose pay estimates are always messed up, whose invoices don't get in on time. All of that kind of hand-holding that people might have been willing to do when they had to meet a DBE goal, they may not be willing to do when there is not one. So make sure that you are a valued member of a team, that you add value to the project. And think about, if you're very small, maybe finding a niche. We're a very small shop, and all we do is work on DBE issues. Don't do other stuff. So sometimes you can do well if you just do what you know how to do well and do it better than anybody else. And then finally, think about focusing on prime contract opportunities. People like to be subs sometimes on these really big jobs, but are there smaller projects where you could be a prime and build up your portfolio? Consider entering into joint ventures agreements with other DBEs. It's a real source of frustration to me over all these years to see how rare it is for DBEs to join up with other DBEs to increase the capacity of what you can do as a team, go after projects together that you might never get on your own, but if you can find partners who complement each other, then maybe that can really be a way to survive and grow your business. Next slide, please. So that's the cases and where we are with everything. I'm going to stop and see if there are questions now, and if not, I can certainly go on to what we need to do, what we need to cover for the new revised DBE rules.
Yeah, Colette, there's a couple of questions in the chat.
Sure.
What are the chances that the Mid-America Milling versus USDOT case, along with the Supreme Court's decision in Students for Fair Admissions versus Harvard and Students for Fair Admissions versus University of North Carolina will result in the elimination of the entire DBE program?
Well, I don't know. You know, I prognosticating about what federal judges will do can be a risky business. I'd say it certainly doesn't look good. I mean, we've essentially lost the Mid-America case at this point. And so if that becomes a trend, I think one thing to distinguish between, and this is something DOT I know is stressing, so I will repeat what I have been told, and that is correctly that the DBE program was not struck down in Mid-America. What was struck down was the use of contract goals, that the other elements of the program remain intact. So, who knows whether or not maybe there might be a challenge to everything about the DBE program. But at least for now, it's only projects in which these plaintiffs are interested in are not to have contract goals. So that is definitely a much narrower focus, narrower outcome than a complete attack on the DBE program per se. Now, will that come, if it goes all the way up to the Supreme Court? I'm not going to sit here and tell you I feel good about what I think that outcome will be, but it hasn't happened yet.
Thank you. Another question from the one case affecting the Indiana, Kentucky, does that mean those states don't have DBE goals on their transportation projects now? Or how has that case impacted those two states and the DBE program there?
Yeah, good question. And really now it's more than just those two states. The approach is that the plaintiffs tell the feds, these two firms tell the feds what projects they're interested in. The feds will then tell the state DOTs those projects, and those projects will be solicited without DBE goals. If a project is not on the plaintiff's list of interested contracts, then presumably they'll set DBE goals on them. That's why I think, for example, this doesn't really affect engineering contracts, because we know those plaintiffs are never going to bid on those. So it's just quote unquote projects that these two plaintiffs are interested in working on in any designated state. And that includes Minnesota, because they listed Minnesota as one of the places that they'd like to do business.
Thank you. Another question, in doing business with municipalities, I am seeing a trend where they have DBE goals, but have set the goal to 0%. What are your thoughts about that? And this is in relation to contract goals.
Well, a DBE goal of 0% essentially is no DBE goal at all. I mean, it's a practical matter. That's interesting that you're seeing people setting 0% goals. I think conceptually, that makes sense to me that you would say that the goal is 0. Because what I would take from that is that the agency did engage in a methodology, applied a methodology to set contract specific goals and determine that the goal for this solicitation would be 0, as opposed to just not having a goal at all or saying anything about the goals. So that may be what they're doing. I don't have no idea what type of methodology they're using to set contract goals. I will tell you that many agencies just seem to kind of make them up. I'm not sure where a lot of these goals come from, so but I can't speak to the specifics of any particular municipality without knowing a lot more about what they were doing or about why they might be finding that there is a 0 goal on a project.
Thank you. One more question. Native American firms are in the program based on political status, not racial classification. How is that addressed?
Oh, that's a really good question. Well, it wasn't addressed. Native American firms are considered Native Americans in the Small Business Act are considered to be socially and economically disadvantaged individuals. So to the extent that the presumptions are struck down, that would include Native American owned firms. Now, that said, however, in the DBE program, we have a little wrinkle that there are 2 types of quote unquote Native American firms. One type is a firm owned by a Native American individual. Presumably, they're in the same boat as Blacks and Hispanics and everybody else. But there is also the provision for firms that are tribally owned. And they're in a somewhat different portion of the regs. I haven't seen anything in the cases that is addressing the issue about tribally owned firms. So I guess we'll see. I honestly don't know that the courts would see that as any different than any other type of race-based program, because they are a political subdivision. But maybe, I mean, it's certainly an argument I would try to make, which is, well, that this isn't race-based at all. This is a political subdivision, not a racial group, and therefore it's not subject to strict constitutional scrutiny. It would just be subject to rational basis scrutiny, which we could probably pass. So, we'll see. And, I guess it's conceivable we could end up with the only group that could be used to meet a contract goal would be tribally owned firms. I guess that's possible.
Those are the only questions in the chat so far.
Okay, sounds good. All right, well, we'll keep going, and we've got a bit of time to the end, and people may think of more questions as we go. But now I do want to pivot to the new regulations, and this is not intended to be an exhaustive list of all the things that you need to know if you want to bid on DOT assisted projects in the DBE program. I'm really just focusing on the major changes that were promulgated with the new rule, which became effective on May 9th of this year. So this is all very, very new. A lot of stuff I think still to be worked out, but it is these types of things that are still very much in play in the DBE program, even in, let's say, Indiana and Kentucky. You still are going to have to do all this. You just can't set contract goals on any contract that these plaintiffs are interested in. So I've divided this up into what bidders need to know, and bidders, of course, can include DBEs. And then after that, what DBEs need to know, put that at the end in case we ran out of time. And then I guess it's Friday, we're going to do the reverse, and we'll start with what the DBEs need to know. But let's talk about bidders. One thing that is now a requirement is that you must have a DBE open-ended performance plan. This came out of a series of projects in New York where there were these monstrous bridge projects, and DOT, FHWA recognized finally that it really cannot set goals on these design build projects up front. How can you set a goal? You don't know what it is, not even designed yet. So the idea now is that the primes will put forward a detailed plan about when they will solicit DBEs, what type of work they'll solicit DBEs to perform, and when they expect all this to happen. These can be changed. It's not written in stone, but this is, I think, a welcome recognition of the reality that you really can't set goals when you don't know what the scope of the project is. Maybe next we'll get some guidance on-call and job order contracts, because that's the same problem, just writ much smaller. A lot of changes about how to count DBE credit for suppliers, manufacturers, brokers, distributors, etc. This is new, and I guess we'll see how this works. The regs now have added a new subset of DBE suppliers called distributors. And the distributor definition permits only 40% credit towards the goal for many goods that are going to be drop shipped. And this is provided that the DBE bears the risk of damage or loss. This is an attempt to deal with the fact that many distributors, manufacturers, whatever, no longer keep these warehouses full of stuff. And so people have been complaining about this to DOT for a long time, that we needed to do something about the fact that an awful lot of things are now literally just drop shipped in time, that they're not going to be held in somebody's warehouse forever. So this is an attempt to get at that. Not sure where the 40% credit came from, but it's the number they gave us. And now we have to try to figure out who fits within what definition, because you now have 3 potential tiers of credit. 100% credit, that's easy for trade contractors. But you get 100% credit for manufacturers, then it drops down to 60% for suppliers, and now it drops down to 40% for distributors. So you've got 3 potential levels of counting when it comes to DBE suppliers. So I would say beware and make sure that you understand exactly how much credit you think you're going to get so you don't end up short. Next slide, please. So we also have the bidders list. And this one, this is a head scratcher, is not quite right, but nobody's exactly too sure how this is all supposed to work. The bidders list requirement has been in the regulations since they were first promulgated in 1999, but by and large, everybody ignored it. So this time DOT says we really mean it. It is a requirement for recipients to report this information to US DOT. There will be some type of portal or system set up to receive these reports. But the initial data has to be submitted by the prime bidder for itself and all of its subcontractors, including subcontractors that they did not use. And I guess I didn't really say that clearly on the slide, so I will fix that for the Met people when I send you the final draft one. So this is now a requirement for bidders to do this. And this information must be submitted with the bid or the initial response to a negotiated procurement. So it is a condition of responsiveness, I guess, but how well that's going to work, I don't know. But you see there the name, what you have to submit, the name, address of everybody, whether it's a DBE or a non-DBE, the race and gender of the majority owner, the NAICS code for each scope of work, the age of the firm, and the annual gross receipts of the firm. Brackets are acceptable. So you could say 0 to 500, 1,000, 500 to 5 million, or whatever brackets, I guess, you decide as a bidder. That's a bit unclear whether or not they'll be standardized brackets, because as a researcher, if they're not standardized brackets and everybody's using their own, that's just essentially pretty worthless data. But you're going to have to get all this and in theory submit it with the bid. And I'm happy to take some questions about that at the end. I personally do not understand how this is supposed to work. But DOT says, well, they'll figure it out. Next slide, please. This is an important one too now, is how to count DBE participation if a DBE firm loses its certification during contract performance. As a prime, you may add or extend work only if it obtains the prior written consent of the recipient. So the Med Council or MnDOT or somebody, you cannot just do it and expect to get credit for it after the firm has been decertified. You don't get credit towards the contract goal if the DBE becomes ineligible because it is purchased by or merges with a non-DBE. So let me repeat that. If your DBE is bought by or merges with a non-DBE, then you are not going to get credit for those dollars. And you must use good faith efforts to replace the DBE if you need additional credit to meet the contract goal. So beware about that. Make sure, and I'll stress this again at the end, make sure that the DBE keeps you informed of its status, and DBEs, you need to be sure to let the firm, your bidder, know if you have that type of a change. Wasn't too sure if there would be people doing ACDBE work today, so I threw this one in here. The ACDBE rules are really kind of complicated, but if you're an ACDBE that exceeds the size of the P&W limits during performance, you can still be counted, but you have to keep submitting these declarations of eligibility. So it's a little bit complicated, and I mean, I can certainly go into it at the end if people have questions. Next slide, please. Credit for using a broker or an expediter continues just to be limited to the fees or commissions. That is not a change. There is a clarification, however, in the definition of a manufacturer. So a DBE that only makes minor material modifications to an item is not a manufacturer for goal attainment and therefore is not eligible for 100% credit. So turning now to commercially useful function and the regular dealer issues. The recipients, like Met Council, must now look at how the DBE supplier is going to provide the supplies to give more certainty about whether a contractor is entitled to count 60%. So this really is more of an issue for the Met Council about making sure that they're looking very carefully to make sure that the DBEs are in fact doing what they need to do in order to get 60% credit. So again, if you're a bidder, my strong advice is talk to the agency. There is a question and answer period. Be sure to ask and make sure that you're counting correctly. And if you're not sure, err on the side of less credit rather than more so that you are not short. And at the time of submission, don't end up having not met the goal and not having submitted adequate good faith efforts to do so, and then finding yourself non-responsive. So just ask for help. Next slide, please. Drop shipping, back to this issue. There's now a requirement for pre-award review of firms that are proposing to drop ship. The review by the agency client. The new supplier or proposed supplier must demonstrate that it's got all the risks during transportation. You'd be looking at a purchase order, a bill of lading. US DOT is supposedly in the process of creating a form tool for people to use on this one. I will say one of the things that it seems to me could happen is that prime bidders will be reluctant to use a supplier that has not gone through this process because it's all got to be done prior to award, and who's got time for that? So I know one of the things that we hear repeatedly across the country when I talk to DBEs, and I've literally interviewed 1,000+ people by now, literally, is that it can be very difficult to get larger prime bidders to use new DBEs or a firm that's new to them. And I suspect that this will put even more pressure on that because people are going to want to use people that they know have been through this process, and that they know that they're going to get 40% credit for them. Anyway, next slide. So now turning to what DBEs need to know. There have been some changes in definitions. Just so you're aware of this, home state is no longer a term that's used. They now have a new acronym, of course, SEDO, socially and economically disadvantaged owner. The old no change affidavit that you filed annually is now called the Declaration of Eligibility. And there's some clarification on the definition of an ACDBE. It does not need to be operational before an application for certification is filed, which makes sense in the concession context because people will put together a new firm to go after a concession. You don't want to be mingling their street side and airport businesses. So there won't have been a business before that could be looked to as having been operational prior to certification. Next slide, please. Now this is in contrast to DBEs, and I will make that a little bit clearer here. I'm not sure it is. That DBEs must have been in operation before they apply for certification. ACDBEs do not, DBEs do. There's also a change in the personal net worth review. In 2014, which is the last time we got substantial revisions, they added an ability to accumulate substantial wealth test. And there were 6 factors to look at. Well, that's now been eliminated and replaced simply with a reasonable person standard, whatever that means. Our firm represents some state DOTs and agencies on certification appeals. And I'm not sure, but that this isn't the full employment plan for the lawyers that represent DBEs on appeal, because who knows what this means. They do tell you that the certifier can consider assets, income, access to those, and other trappings of wealth. Okay, whatever that may turn out to be. Individual determinations of social and economic disadvantage are now to be done via a personal narrative. There was the old Appendix E that provided for this list of factors and things people had to do, and that is now gone. So now it's just a personal narrative that is required. I think the objective here was to make it easier for firms that are owned by white men to get certified as DBEs. Next slide, please. There's some modernization provisions of ownership. These are a little bit technical, but just know that they're out there. There is now a discussion of investments and the role investments play in capitalizing a firm that I think is welcome. New information about control. The socially and economically disadvantaged owner must run the show. And the test is managerial oversight, revocable delegation of authority, and critical and independent decision making. Some provisions were removed that had caused headaches for years. So, for example, licensing. Does the owner have to hold the license? Let's say that there's some general contractor license or plumbing license that they need. Does the owner have to hold it? Some states said yes, some states said no. So the answer now is no. You're not going to look at differences in remuneration, outside employment, family relationships, whether a non-CEDO remains involved in the business if it's been sold or transferred. So all of that is to clean up issues that were being treated very differently around the country so that we get some uniformity here. Next slide, please. Clarified about holding companies. That wasn't clear either. There is now one level of ownership above the DBE that is permitted. So you can have a subsidiary and a parent, but not a grandparent. So at least now it's clear. Interstate certification, these are big changes here. There essentially now is nationwide reciprocity. Under the old approach, there was, you could do A, which was just accept the other state's file and certify that firm in your own UCP. Then there was B, which is make people go through the whole thing, soup to nuts again. And most of the states chose B, which was, I think, not what DOT was hoping. So now there is a much more streamlined process. A firm must be initially certified in the state in which it maintains its principal place of business. And then all it has to do once it gets that certification is send a short cover letter, an image of the directory entry, and a declaration of eligibility to the new state that it wants to be certified in. Next slide, please. And the new UCP must certify that firm within 10 business days, unless there's some really countervailing reason not to. The new state UCP can review the DBE if it's got reasonable cause to think that it's not eligible. If it does that, it must notify other states where it's certified and provide a procedure for them to concur or not in the outcome. Next slide, please. Business size calculations. This is probably welcome to some folks. The statutory gross receipts cap is now $30.4 million, but note that the regulations still require a DBE to meet the size standard in the NAICS code for which it is going to do work. So yes, overall, you can be up to $30.4 million, but if you're a DBE trade contractor, you still must meet that $18 million cap for trade contractors. One thing that's changed now is that these calculations are based on a 5-year average, not 3. Gross receipts must be calculated on a cash basis, even if you use a different accounting basis in your business. But cash is what the agency is going to look at. And then again, for concession joint ventures, the size goes to the DBE's interest in the concession. Next slide, please. P&W cap has been raised for the first time since it's been 11 years. And now it's gone from $1.32 million to $2,047,000. This is going to be adjusted every 3 years based on Federal Reserve data and inflation. Importantly now, retirement assets are excluded in full. Used to be you had to take your retirement assets and discount them down to present value, but now they are excluded in full. That may make a difference to a lot of people. It also removes state marital property and community property laws, and you can exclude half of the value of your household contents. Before, there was no way to do that, so you were presumed to own it all, even if you had a spouse and presumably really only have access to half of that. Next slide, please. So if you're appealing a decision, the appeal time is now 45 days, down from 90. I think DOT is real tired of things just dragging along. And now the waiting period begins when the certifier sends the decision. Decertification is now a 45-day deadline for an informal hearing. Those used to just go on and on and on and on, and a 30-day deadline for a decision. So again, really trying to speed up this process. Next slide, please. So counting DBE certification, DBE participation after decertification. And, we did go over this. I wanted to be sure that the DBEs focused on this as well, because if you get decertified, you really do need to let your prime know what's going on. Next slide, please. So finally, and Megan asked me to be sure to stress this, that this does require some increased compliance by DBEs. Met Council is what's called a responsiveness organization. That means that all these materials are due at the time of bid or proposal submission. Some agencies are responsibility organizations, and you can do it later, but Met Council, you have to do it all up front. So that means things like supplier credit, supplier forms, information for the bidders list. DBEs have got to get that stuff to primes, otherwise they're just not going to be able to use you, and that's regardless of whether there's a contract goal or not. So just know that the regulations do place more of a burden on a DBE now, to let your prime know if you've been decertified or if you're going to be selling or merging with a non-DBE. These are all things prime contractors need to know, and DBEs are in control of that information. So I think that is my last slide. I think I had 30. Is that right? Yes. Okay. So any questions? We're getting up on our end of time here, but we're doing fine.
Yep, there's one comment. So North Dakota DOT uses Form B for bidders list info. The next question.
You said uses Form B.
Correct. Yep, for bidders list info.
Okay.
This next question, North Dakota DOT has taken the stance based on US DOT guidance that to get 40% credit, the distributor must use their own equipment to deliver the product. Otherwise, it will be considered a broker credit, counted only at the markup rate, for example, AC oil. Can you provide additional guidance on where the US DOT says drop shipping is allowed?
I can't provide you any additional guidance on that. We're still waiting for guidance from them. And I'm very reluctant to speak for them and then turn out to be wrong about what it is that they decide to do. It seems to me that this gets tricky because if you are somebody who's going to drop ship, are you not allowed to rent trucks for the purpose of moving that particular haul of materials or supplies, or are you supposed to just have these trucks sitting around until it's time to drop ship? I don't think that people have worked those issues out completely yet. So I think there'll be some feeling your way. My advice for North Dakota DOT is whatever they tell you, get it in writing. Because you may start getting inconsistent information from people. That would not surprise me. I'd like to say I wish it wouldn't happen, but I think it's entirely possible.
Thank you. Another question, do you have any indication how many projects the Mid-America and trucking firm will want or have wanted to bid on from Minnesota transportation projects? Have they already started saying we want to bid on this and thus the DBE goal has been removed?
Good question. I think somebody from MnDOT would have to answer that. I saw the list from Illinois because they are a client right now. So, been doing work for them, and we just finished up a disparity study for them. So I haven't seen a list from MnDOT, and I don't know if there's anybody on here from MnDOT, or maybe somebody from the Met Council knows who there you could ask about that, because I just don't know.
I did see a couple people on from MnDOT earlier, if they're still on. I know Lee was on. I did have some conversations about this with folks from MnDOT just to get a sense of when the last time Mid-America Milling had bid or worked on a MnDOT project. What I can say about Met Council, we have not been notified of any projects that they're interested in. So is there anybody from MnDOT on? I do not want to speak for them.
Lee just put in the chat, MnDOT has not received notice from USDOT that either contractor is bidding on an advertised project.
Okay. All right. Well, and these firms aren't that big. So, some of this might be wishful thinking or wish casting. I heard that phrase the other day. I think that's a great one. I'm going to start using it. This might be wish casting on their part about where they want to go. But I just think people need to be realistic about the fact that there's nothing stopping people from filing very similar suits in other states. I mean, there just isn't. So my expectation is that there will be more of these cases coming. And, who knows what the new incoming administration will do in terms of wanting to support or not the DBE program. There's not a whole lot in Project 2025, and I've read the whole thing now looking for this about the DBE program, but there's plenty there about opposition to civil rights programs at a more general level and race-based programs. So, who knows who knows what's going to happen.
Thank you. How did the new rules impact contracts in place underway before the rules went into effect on May 9th, 2024?
They don't. They only come into play on the day that they become effective. So if you have pre-existing contracts, then the changes don't apply. That said, however, if you have some concerns about any of it, talk to the agency, or if you're a subcontractor, try to talk to your prime and get some clarification if there's some particular issues that you're concerned about. Never hurts to ask.
Thank you. We have a couple more. When speaking about drop shipping, you stated that during pre-award that a review will be performed to ensure that ownership has been transferred to DBE. Proof will be PO and bills of lading. Are you saying that the DBE will have had to purchase and show proof of purchase prior to award of the subject project? The DBE purchase without any assurance that they're even given that they are even the awarded subcontractor?
That is a really good question, and I'm not sure what the answer to that is. The answer I would like it to be, okay, so take that for what it's worth. The answer I would like it to be would be for the DBE to be able to show a pattern and practice that's already existing. Hey, here are the bills of lading and whatnot from the last time I did it, so that they don't get in the position of having to buy stuff before they've been awarded any work. I mean, who would do that? So I'm hoping that's the answer, but I don't actually know that that's the answer. I think this whole pre-award scheme, I have to be candid. When I talked to my buddies at USDOT headquarters about how this is all supposed to really work, I don't know that they thought all of that through yet. So I would say stay tuned, but it does not seem to me to make any sense to tell a firm, especially a DBE, go buy a whole bunch of stuff so that then you can be evaluated about whether or not you could get an award to pay for all the stuff you just bought.
Right. Okay. Thank you. Regarding holding companies, is there any precedence for employee-owned companies such as an ESOP where a firm is held in trust for benefit of employees? An allocation of shares to CEDO employees meet requirements?
Well, depends really what you're asking. The DBE program has never permitted an ESOP, that's an employee stock option program, to be certified as a DBE because they're not owned by the firm then is not owned by a socially and economically disadvantaged individual. So an ESOP has never been eligible. It is, I suppose, possible that you could have an ESOP as the holding company and then have a DBE that is owned by individuals as the subsidiary. That might work, but otherwise it doesn't change anything about employee ownership of companies. But in theory, I don't know why you couldn't have a holding company. Not sure under what set of facts that would make sense, but at least in theory, you could have a holding company that was an ESOP, that the subsidiary was a DBE.
Okay. And then one final question. I am curious about the supplier counting. Who is responsible for ensuring that what the DBE lists on their affidavit is in fact how they should be counted? 60/40. If a supplier says they are a regular dealer but really don't warehouse the percent necessary on the project and it gets reviewed by the recipient later and found to have been a distributor counted instead, is the prime contractor held accountable or penalized?
Well, my instinct is that the prime contractor is going to be held accountable because who else are you going to hold accountable if you're the agency at that point? It's the prime that they have the contract with. So prime bidders, I would be, what do I want to use? Careful about just accepting whatever it is that the DBE tells you. Do your own due diligence and make sure that you're comfortable with how it's going to be counted. Because if you get into performance later and the DOT or Met Council or whoever says, no, we're not going to give you that much credit, you're going to be short and it's going to be your problem. So you won't be able to pass it off to the DBE and go, well, that's what they told me, so that's what I did. Nope. my instinct, and it's a strong one, is that the prime is going to be held responsible for every element in the bid that was submitted, including whatever the counting turns out to be. So be careful about that. That's one of the reasons why I'm uncertain about how this is all going to work. And especially when you think about the chaos that it can be on bid day with people, you know, back in my old days, back when you had to stand there with the phone and, you know, in the quarters before we all even had cell phones. But now people are texting quotes at the last minute. Same thing with the bidders list. I don't know how this is supposed to work. Now, I think for agencies that don't put out a lot of contracts on any one letting, that might be okay. But one of my major clients is TxDOT, and TxDOT will have 200 contracts on a letting. And it's just madness. So I don't really know quite how this is all going to work, to be honest. I saw something go by in the chat. I can see them as they flash up, but then they're gone.
Let's see.
We have a hand up.
Yeah, go ahead.
Megan Solberg has a question.
I was just going to touch on to that question for you, Barb. I did put a link to what the DOT form is that's currently being published. That is right now what the council intends to use. And at the bottom, it does have a spot where the DBE is affirming that the information is true, but then it does say in the second spot where the bidder has to sign, the bidder acknowledges its responsibility for verifying the information provided by the DBE named above and ensuring that the counting of the DBE's participation is accurate. Any shortfall caused by errors in counting are the responsibility of the bidder.
Okay, yeah, well, there you go.
Barb, I see your hand. Let me try and oh shoot. I was going to try and unmute you, and then you went away from my list. Give me a second.
And it looks like MnDOT, somebody who were on from MnDOT says they're going to be using the same form. Yeah, I mean, I think that's a form or for something very similar is what everybody's going to use. But as I say, the primes will be responsible. The bidder is going to be responsible ultimately for that information because that's who the agency has a contract with, not the sub. So just from a legal perspective, that'd be the, you know, those are the people that I would go after. As I said, one of the things that concerns me is that in the heat of trying to put these bids together and just, you know, all the chaos that goes with that, that it will make it even less attractive for primes to use a new DBE or someone with whom they aren't super familiar, and that they have a really good comfort level that what they're being told on that form is accurate.
Barb, you should be able to unmute yourself, I think. Says I allowed it. You might have to send it in. I don't.
Barb, now you should be able to unmute yourself. Barb, are you there? Okay. Never known Barb to be shy, so she's having.
I can't help you with Teams. We don't really use it, so it's I don't know. But I thought I saw something go by about the form again, or was that the same question, Tina?
Oh, MnDOT also plans to use that form
as
well. When will these changes be implemented on MnDOT project lettings, I guess. I don't know if there's anyone from MnDOT that can respond. Maybe not. Or just type it in the chat.
Well, I mean, I would say this, I mean, given that the regs went into effect on May 9th, I would assume that the short answer pretty much is now.
Now. Yeah.
Oh, somebody says if our special provisions get approved January 1st.
Let's see. And then I guess there's one question above. Are there any issues on employee goals on projects? Percent female, minority works.
Wait, I'm sorry, what was it?
Are there any issues on employee goals on project?
Oh,
i.e.
employee. Okay. Not yet. Not yet. But I did just see a case out of Philadelphia. It's going back to the trial court where it was a challenge to project labor agreement and employment goals. And the district court had dismissed the case, saying that the bidders really didn't have standing to bring the lawsuit and some other more technical kinds of issues. The Court of Appeals reversed that and sent that back. So I'm certainly going to keep my eyes on that one. It was in the context of a PLA, but they were also complaining about the workforce goals on there. And Project 2025 does have quite a lot to say about things like Davis-Bacon and workforce. So I don't think there's a whole lot of support for that from the incoming administration, but I guess we'll see. And one last comment too about employment cases and why there have been so few in comparison to contracting. And I've thought about this a lot over the years because, you know, a lot more people have jobs than own businesses. So you would think that there'd be more of them, but I think it's that the contracting community is organized and they're repeat players. So if you're Mid-America Milling and you want to go bid in 23 states and all this other stuff, you're going to be in the game over and over and over again. Whereas with the job, it's one-off. You got this job or you didn't. You're not constantly reapplying for the same job over and over and over again. And so I think the incentive to complain has really always been much less. But that doesn't mean that somebody won't take off after employment programs too.
So she put it in the chat so she couldn't unmic or get her mic to work. I was just going to say that this is so wrong to expect primes to be responsible for what a contractor states. It's as if you are expecting them to do on-site videos. And she also said, I just read that there is a case to challenge the workforce goals for race and gender to USDOLI watching it. Let's see. And then Courtney stated, I totally agree with Colette. It is a scary thought as a prime contractor to trusting the DBE firms with accurately counting the credit. There are bid days that we don't receive quotes until a half hour before the bid letting closes. It will for sure be a big change for all involved.
Yeah, I do. I just think that part of the problem is that sometimes the people that are writing these regs have never sat with an estimator on bid day. And I have had the privilege to do that. And my goodness, is it eye-opening about how that actually works. One of the things I think that perhaps Met Council and the other agencies, as they're thinking about beefing up their supportive services and really trying to help these firms, one thing that they might want to focus on is making sure that if you are new, if you are small, if you want to go to a prime that you don't have a relationship with already, that you haven't worked with, do not wait until the last minute. Try to establish a relationship ahead of time, especially if they're repeat bidders and you are going to be trying to do the same kind of work more or less on numerous contracts. Get out there, go to the meet and greet, sit down with these people, get them comfortable with you. Maybe if they're willing, walk them through how you came up with the amount of credit you think that you're supposed to get before bid day. Don't just wait, because it's just chaos. And so I think that that's really going to be a problem for new firms. And it's hard enough to be new and small and break into any of these markets. But if people now have to be responsible for a set of decisions you made and they don't know you, maybe.
I just wanted to just reinforce what you just said, Colette, about building relationships. And many people hear me say this at the events that I talked talk at is that as agencies, it's our responsibility to create the space for those relationships to happen and occur. But it is the responsibility of the DBEs and the primes to foster those relationships and hopefully grow into partnerships. One of the best practices that I find in talking to large contractors and longer established bidders is they do invite these small businesses into their place, get to know them, understand what their expectations, requirements are, and risks, because their feeling is if a DBE actually understands their risks, then they'll get better quotes and better pricing, and they won't put that unknown risk into their bid. So it's just a best practice from a relationship standpoint.
Yeah, I want to echo that completely, and it's just going to get worse. For one thing, the jobs are bigger and bigger. When I first started to practice law, and I started out life as a construction lawyer, and I'm some ways I still kind of am, that $100 million job was huge. Now, I've got some big, international primes. Nobody's going to get out of bed for $100 million. So everything is really big, and the bigger it is, the more risk there is, and there's more risk, the more risk that has to be spread. So I think that anything that a DBE or any small firm can do to reduce the risk profile that they present to a prime contractor is really important. And that's true on the consulting side too. So you'll ask yourself, if I were looking at me through the other side's lens, where would I see that I'm risky? If I'm really strong in some areas, like, hey, I've got a great estimator and she came from, I don't know, I'll pick on a client, Kiewit or somebody, was chief estimator there for 10 years. Talk up what you do well so that people feel more comfortable with you. Because the thing about construction is essentially risk shifting. That's the goal. Everybody wants to get as much risk off of themselves and onto somebody else as they possibly can. So the extent that you can do that, and I'm glad to hear, Ashante, that Met Council, that you all are creating those spaces for folks, but people got to show up and they've got to do the work. And I'm not trying to lecture DBEs. This is not, me with, like playing, President Obama, pull up your pants. But I do think that people are going to have to do more, and maybe they shouldn't have to, but, it is what it is, to make sure that these firms know you, that they are comfortable with you, and that you have addressed all the questions that they have, and that you are proactive about seeking them out. Because if there are no more contract goals, folks, then you're going to have to make sure that you're on their radar, because they won't necessarily be looking for you.
Well, I don't see any more questions and I don't see any more hands. So I want to first thank you, Colette,
Oh, it's
for
fun.
providing this. It's always a pleasure to gain from your experience and knowledge. I always feel like I'm smarter each time.
Did you tell people how long we've known each other?
I tried to without revealing, how old I am and how long I've been
How
at
old we
this.
are. No, boys,
Yes.
be glad. Otherwise, you aren't here. So with
True.
with age, hopefully comes some wisdom.
True. And thank those our external partners in attending this session. If you have further questions or specific questions about how Met Council will be administrating some of these contract requirements, our plan, our three-phase plan, please reach out to Megan Solberg. Of course, you can always reach out to me, but Megan is our small business unit program manager, and she will make sure your question gets addressed. Megan, any closing things that you want to say?
No, thank you. Thank you, Colette, and thank you for everyone that joined us. In addition, feel free to email me if you have that. I did also put our DBE mailbox in the chat, so you can answer that and that will get routed to me as well. So thanks again for joining, and we will
Thank
look to
you.
partner with you, and thank you, Colette.
All right, thank you, everybody, and particular thanks to Megan for making all of this happen. She did most of the work there, honestly. We'll be doing this again on Friday, and so Megan and Ashante, I'll be in touch before then.
All right. Take
Thank you.
care.
Thanks,
everyone.
everybody. Have a good rest of
Thank
your
you.
afternoon. Bye.
Bye.